Hi, good morning, everyone. Welcome to this August 13th, 2021 stakeholder meeting. Today we have several items to go over. First, we'll be talking about the overhaul of Chapter 41 audit chapter, and specifically we'll spend some time also on the new rule that sort of outlines what is a tamper-proof container for the purposes of alcoholic beverages to go. I know there's been a lot of interest in that, and we want to make sure that that rule works for you. And then we've got a couple of important advisories to go over, and I will hand it off to Amanda Collins and Matthew Cherry to do those. With that said, let's get started on Chapter 41. I just want to run through it with you very quickly so you can kind of see what we did here. The first thing that I did, of course, as I always do, is reorganize the chapter so that all of the generally applicable provisions are at the front, at the beginning of the chapter. And I also added a scope and applicability section for, which is what we've been doing at the beginning of each chapter as we've gone through our revision process. So we have the new scope and applicability section. Then we have timely filing of reports. There's been some questions on this. If you're filing in Ames, it's going to be pretty much, right away. So as long as you're filing on 11/59, you'll be fine. If you're still mailing in, and we don't encourage that, but if you are, it has to be postmarked on the date that it's due, or by the date that it's due. Required signature. It's the current rule 4143, report and record retention. We're trying to sort of standardize this unless a statute requires something different. We're trying to standardize to nothing more than a 2-year retention period. And records and invoice requirements. And then our general failure, 41.6 failure to make reports and records. It's just a general section to cite for enforcement purposes. That's subchapter A. Subchapter B, we have some more substantive requirements, what kinds of basic general records are required, which is current 4123. Some revisions. Compliance reporting is the same as 4122 currently. Carrier report. In the next thing we've done here is at 4114 at SEC, we've moved some rules in that were in chapter 35, the enforcement chapter, just because it seemed to us that they made more sense and would be easier to find in this chapter. It just makes more sense that these rules would be here adjacent to other types of record keeping rules. So the next few rules are currently at 35.1, 35.2, and then 4116 tamper-proof containers we will come back to. This is all brand new. It definitely needs some feedback on this, but we'll come back to that in a moment. Vehicle identification and liability, we've simplified that a bit, but it's essentially the same. And we've moved up and we've moved that also from chapter 35. Let's see, we have the regional forwarding centers rule. It's generally the same. Warehouse registration, about the same. Bonded warehouse report, minor changes. Record requirements for export. We've had some updates to the statutory citations because the private carrier permits eliminated September 1st. And so that's basically a consolidated of the current 4111 and 4155. They have enough in common that we could just eliminate one rule and make it one rule. Then we have sale and delivery of malt beverages. Obviously, we could eliminate one of those rules because there were separate rules for beer and ale. Let's see. A few more general records required. Then subchapter C is excise taxes, and the changes to that chapter are basically just to update for beer and ale consolidation and to make some other minor changes. We have added here in 4132K, the out-of-state winery direct shippers that are using a third party to either package or keep their records. It's their responsibility to make sure that whoever's doing that actually keeps those records, so that if we go looking for them, they're there. Excise tax exemptions. Okay, so what I've done here on the exemptions is the first rule, 4133, says these kinds of transactions are the ones that are exempt from excise taxes, A through E. And then as far as A through D, then each one of those has a specific section that outlines the requirements that you must meet in order to qualify for that excise tax exemption. So, then we go through sacramental wine, export malt beverages not legal for sale, destruction, and is that it? And destruction. Right. So sales of alcoholic beverages for industrial purposes are also exempt, but there's no corresponding other requirements other than it be for industrial purposes. And that was a change last session. Okay. The remainder of the excise tax subchapter are just minor updates and for beer ale consolidation and other editorial things. Subchapter D, we now have sales of alcoholic beverages not in the regular course of business. It's a new subchapter heading that we feel like just describes the contents better. Sale to and by lien holders is there, sale by a carrier, sale after cancellation, expiration, or voluntary suspension of a license or permit. So all of these times that alcohol is sold, but not in the usual way, just put those in their own chapter. Subchapter E is private clubs. We'll probably need to come back to this one a lot as well. We've tried to reorganize this subchapter in the same way that we always do. So general provisions up front, including definitions. And we've tried to modernize it some as well. No more requirements for well-bound books. And consolidate where we could. There was a lot of rules that were repetitive of other rules. We also, that's it. We also drafted a new rule, 4154, regarding locker systems. Those are pretty popular, and we want to make sure that we are regulating those appropriately and that people know what they're supposed to be doing. Finally, we have identification stamps in their own little subchapter, and nothing has changed there really. So with that said, let's go back to, well, first of all, does anyone have anything they want to talk about that is not the tamper-proof containers rule 4116 or something in subchapter E, private clubs? Okay, Marcus, go ahead.
You'll have to unmute.
Oh, I have to unmute. Okay.
No, he will.
Okay. Can you unmute yourself?
Can you hear me now?
There you go.
Okay. And apologies, somebody is with a jackhammer right outside my window. So if you hear that, apologies. 4143, sale after cancellation, expiration, or voluntary suspension. Subsection C, I would recommend after cancellation to add or voluntary suspense, just for clarification purposes.
Okay.
I think that's what you guys intended, but just want to get that in. And then This one is just cleanup, but 4151 in private clubs, you've got two subsection Ds.
Yeah.
And then I will cede my time until we get to the relevant sections you just called out. Thank you.
Anyone else on the bulk of chapter 41 other than 4116 and subchapter E? Okay, I'm not seeing anyone at the moment. As always, as y'all find things, this isn't your only opportunity. This is just the first opportunity. So you can always call me or send an email. And I do appreciate things like telling me I have two subsection Ds. That's always very helpful. Okay, with that said, let's go back to rule 41.16. So as y'all know, House Bill 1024, we can do beverages to go forever now, yay, until something changes. But the bill also required the TABC to adopt a rule that kind of explains to people what qualifies as a tamper-proof container. So to that end, we drafted this rule. Come on now. There we go. So I've included, so subsection B, subsection A is who the rule applies to, who's actually going to have the ability to sell these beverages. Subsection A2, so a holder of either a wine and malt beverage retailer's permit or retail dealer's on-premise license. We recognize that there are some situations, for example, like when you're in Lukenbach, that you can walk up to, a bar, get your drink and walk away and go somewhere else. We don't want to prohibit that or require sealing of that container in a tamper-proof manner, because you're not going to be in a car, you're just going to be walking around. So that the purpose of that A2 is to make sure that those things, you're not having to unnecessarily seal containers in situations where people are just going to be walking around with it, not getting in a car, because that's obviously what we're trying to prevent. And then subsection B, tamper-proof container. The first two, 1 and 2, were part of the statute. So we just added those in here. And then the things that we've added are sealed with a tamper-evident adhesive tape or seal, which I think is the most common way that this is being done right now. And it's relatively inexpensive. The seal has to have one or more indicators or barriers to entry which, if breached or missing, can reasonably be expected to provide visible evidence that tampering has occurred. That language comes actually from FDA requirements for, like the seal that's on your medicine bottle or whatever like that. So it seemed like a good description of what we're looking for there to me. And then the fourth specifically called out method is sealed mechanically on premises with a can seamer. This is I'm going to need some help on this from y'all because sealing can seamers, sealing cans on site, that kind of thing. There's a lot of new technology happening with that. A can seamer, I think it's the most common, and I don't know what other methods people are using. And I also don't know, I want to make sure that I'm using the terminology that makes sense to your clients, and it's the correct terminology for the machine-based sealing methods that they are using or might be using. Subsection C, we wanted to call out some things that don't qualify specifically. The 2 and 3, sealing with a sticker or adhesive tape is not tamper evident. You can't just put Scotch tape over the hole and call it sealed. That doesn't work. And filling a reusable, resealable container such as a growler, unless it is sealed in a manner described in subsection B. So even a growler would need to have some kind of tamper evident tape over it. This list, of course, is non-exclusive. It's just a way of us saying these are some things that we don't think are, that we are telling you don't comply. C1, this one is causing some confusion, and so I could use your help with this one too. There's a lot of folks when you tell them, oh, we have cocktails to go now, they say, oh, so like New Orleans. No, not quite like New Orleans. And that's what C1 is trying to get at, is that no, it's not there. The rule there is that, if it's a frozen beverage and there's a straw, taped over the hole, that's sufficient. And I want to make clear that is not sufficient in Texas. But I understand that there's some confusion about how this is worded. So if you have any ideas for a better way to word it, it's less confusing, but that just kind of makes people aware that, just because that's the way they can do it in New Orleans, that doesn't mean that will fly here in Texas under the law that we have. So with that said, let's open it up for discussion. First of all, I wanted to recognize that the Texas Restaurant Association, Kelsey, sent in some comments. And Kelsey, I appreciate those comments. They're very good comments. I wanted to talk with you about them today. Her first comment was about the confusion with with C1, what the purpose of that was, and frozen drinks and all of that. And then there's also a machine that she sent a picture of that is a cup sealing machine. I've never seen one of these. Obviously our purpose and our goal in these rules is whatever it is that you're using has to be tamper evident. You have to, if it's opened, it has to be very obvious that it's been opened. I don't really know what the cups look like that are sealed with one of these cup sealing machines. So maybe if someone can describe that a little bit better, that might be something that we could add to the mechanical section with the can sealer, a cup sealer. So with that said, Kelsey, I'm going to open the floor to you. If you want to expand.
Can you hear me?
Yes.
Can y'all hear me okay? Oh, good. Okay. Sorry, I'm in Arkansas in a little town on a lake. So internet reception is not the strongest here. So I'm kind of piecing together technology. So thanks for bearing with me. Yeah, I'm glad you addressed C1. I figured that was sort of the intent. I also thought about the sort of drive up daiquiri bars that we've all seen. I figured that was kind of part of what we're trying to get at there. I just think we have to be really tight with the language so that we're not accidentally capturing in C1 what is allowed under B, right? And so we don't want to get into this kind of circular place where, well, I think it's covered under B, but then I think it's excluded under C. So where does that leave me? And in terms of the machines, I'm not an expert in that machine either. One of my members sent it to me. I doubt people are using it very extensively, to be honest, because it's a lot more expensive than some of these other methods you've talked about. But I think it would work under the B language because it appears to me that it's essentially that there is a seal. And so once you pull that kind of, it's like a plastic sealed lid, for lack of a better word. But once you pull that back, it can't be sealed again without that machine. So I think it would be fairly evident that it's been opened or tampered with. The other thing I think we should think of is kind of those, almost like a Coke bottle or a Gatorade bottle that's plastic. And once you twist it, it breaks the little connectors between the lid and the circular piece under the lid. This is where my lack of engineering really comes back to bite me. But those kinds of mechanical processes where once you break it, it is obviously tampered with. I think that should be included, but just some more specific scenarios to think through and make sure the language really does match the intent. But thank y'all so much for this process and for hearing from us and all of the stakeholders. I think we're going to get a much better product as a result. And I think this is exactly what was intended in the bill when we said, you know, TABC come up with this definition so that it can be a living definition that matches what is really happening in the world and what the technology is, while we keep people safe. So thank you for this.
Thank you. And yeah, and I want to, you know, also point out that our lists here are not exclusive. So, you know, if there's something different, people can always check with us first if they want, you know, hey, we're doing something that's not on your list. Is this okay? So it's not exclusive lists. Anyone else? Oh, goodness. Okay. We have messages. A pilfer. I love that. A pilfer proof cap apparently is what that type of cap is called. Pilfer proof. I just like the word pilfer. And Stratman seconds the pilfer proof cap comment. Pilferage. Okay. It's cracking me up. Okay. All right. All of these are messages that I will look at later. Anyone else wish to speak on 4116? Go for it, Mr. Schwartz. I see you're unmuted, but I'm not hearing.
I'm sorry. I did not turn on my microphone. A2, two things. One, you know, I would just note that HB 1024 did not affect the ability of BQs or the BFs to sell in any manner. You know, that section applied to, you know, for the first time off premise, these two had already been able to sell off premise. So to the idea that this somehow constrains what they could previously do with no law change, I'm not sure exactly what you guys are going for. If you do want to retain the language, I would just note also that I would recommend changing it from person knows or should know to should reasonably know, just for a clear legal standard, so to speak. For A2. And then in C1, however kind of that's going to be amended, I would recommend that that beverage be changed to alcoholic beverage, just for clarity purposes.
Okay, thank you.
Thank you.
Anyone else? Oh, Charles. Yes, Charles Bellenrep. You got your hand raised?
Yes, just a comment about C3, suggesting that growlers need to be sealed in a method from above. Growlers have never traditionally been sealed with tamper-proof seals or in a bag or so forth. I'm just curious why the change, what appears to be a change, if that was intended for growlers at this stage.
I don't remember why. It's because it's
With
mixed
those-
beverage and
I think the intent was to, because we have all these different permits and license types, doing
Oh, that's
deliveries
right.
to streamline what everyone is doing instead of having multiple different types
That's
of
right.
beverages with different requirements.
so when we were drafting this, we realized that it was possible for us to have different standards for different types of containers, and that would be, we thought that would be confusing, and that it would be best to just standardize so that every type of container that's leaving the premises has to be tamper-proof, which would just be like a piece of tape, rather than having a separate standard for growlers or for malt. That was the thinking behind that. If you think that's really problematic, shoot me an email and we'll look at it.
Yeah, I'll follow up. Good. Yes, thanks.
Anyone else? Are there any other raised hands? Anyone else on 4116? Okay. In that case, let's move on to the private club subchapter E. And would anyone like to open up that discussion? Private clubs. It's perfect. That can't be true. Okay, so I'm not seeing any hands or comments in my chat regarding the private club subchapter. I kind of expected that y'all would have some issues or feedback on that because there's a lot of things that have moved around, and the new locker system rule. But seeing none, I'll close out this conversation on chapter 41 unless somebody has anything else. One comment. Go ahead, Marcus.
Unmuting myself. Okay. I may be reading this wrong, and this may go to my ignorance of private clubs, but are there instances in a private club where a member can bring on their own alcohol, can do a BG? I may be thinking out loud here, but for the private club malt and wine permit,
Not sure with private club.
the reason I bring that up is for the locker system. Well, I guess they couldn't store their things in the locker though. I was talking to 4154F and just thinking if no members can remove alcoholic beverages once there, if that would cause an issue. I can look into that and get back to you.
I don't have any experience with locker systems, so I will appreciate your feedback on that. And yeah, not removing is, yeah, it's in the code. So anyone else on chapter 41? If not, as always, give me a call, shoot me an email. You can do rules@tabc.texas.gov or shana.horton@tabc.texas.gov, or definitely can call as well. And these will be are slated to be proposed at the September 21st commission meeting. So the sooner I get your feedback, the better, because we want to have it in really good shape before it's proposed, because that's the easiest time to make revisions. So definitely keep the comments coming, and let's whip this into shape before then. And with that, I will pass it off to Amanda Collins. We're actually going to switch chairs to talk about advisories.
Hey, good morning and happy Friday.
The 13th.
Oh, don't jinx us, knock on wood. So my name is Amanda Collins, and I am the Associate Director of Strategic Initiatives and Performance Improvement. And I will be introducing you today items 3 and 4, which is advisories for cash and credit law requirements. And then for certain nonprofit entities serving alcoholic beverages at fundraising events. At the end of each item, I'll open the floor for questions and comments or any recommendations. And as just a friendly reminder, you'll have about 2 weeks, 14 days to provide any comments or recommendations that you may have that you can't think of this morning. And you can send that to the advisories@tabc.texas.gov email. So without further ado.
Oh, I totally skipped. I skipped rule 3394.
We can come back.
Okay, we'll come back to that.
Okay.
Forgot we were talking about that.
So when I wrap up the advisories, we'll come back to Shayna. We have one more rule to introduce to you all. All right, so starting with cash and credit law requirements, this particular advisory we have listed as a new advisory, but essentially it's a consolidation of 7 current cash and credit law advisories that is located on the TABC advisory and bulletins webpage. We figure having a one source document will make things a lot easier, life a lot easier for industry as well as internal staff members when locating information in terms of answering questions in the field, or if a permittee needs to locate a document that provides additional clarification outside of what's in rule and what's in statute. Also, the advisory was also, we took the opportunity to incorporate amendments from the rule 45-130, which provides clarification on the 4-day mail-in period in terms of credit law when you're mailing in that payment. The payment is still due on or before the due date, so that has not changed. So it just essentially, we just provided that additional clarification. And then of course, that last page before the statement from TABC, the payment calendar, we have, thank you to our communications division, we have updated that calendar and made it more reader friendly. So I will open the floor for any questions or comments that you may have.
Okay, we'll go back to that.
I see one question coming in regarding chapter 41.
We'll go back to that.
We'll come back to it and get those answered for you. Okay, I don't see any questions or comments coming in. No hands are raised. And once again, this morning will not be the only opportunity for you to provide any questions or comments. You can email our advisories inbox and provide any recommendations that you may see with this particular advisory. And again, you have 2 weeks before we finalize and make any last minute edits to this particular advisory before publication for the advisory and bulletins webpage. Okay. So we will move on to marketing practice advisory 026. This is certain nonprofit entities serving alcoholic beverages. Okay, And essentially, this advisory is just an amendment to the current advisory that is on our website under advisories and bulletins, which is charitable, civic, and religious organizations serving alcoholic beverages at fundraising events. The guidance in terms of that advisory has not changed. We simply took the opportunity to make sure that this advisory mirrors the new rule for 3378 and 3379 that addresses nonprofit entities hosting a temporary event or serving alcoholic beverages at a fundraising event. Now, also we took the opportunity to update the advisory to incorporate examples of permissible practices when it comes to a nonprofit entity hosting the event under options 1, options 2, option 3, as well as restrictions. And I'm going to give you a couple examples of what those practices, or excuse me, examples of what the guidance is that is typically verbally explained in the field, and we took this opportunity to actually put into the advisory. So example 1, for option 1, in terms of a nonprofit hosting an event at an unlicensed location and they're serving free alcoholic beverages, the good business practice and common practice has been that the nonprofit entity can pick up the product, but the product cannot be delivered to the unlicensed location. So that is now provided in this advisory in terms of the upper tier members may not deliver donated product to the unlicensed event, but the nonprofit entity may pick up donated product from the upper tier members' premises. So that is an example in terms of option 1 of language that is not in the current advisory that we have now added in this amended advisory in terms of what has been verbally discussed and now is in writing. And again, I'd like to point out that the list of examples are not exclusive. This is just to provide opportunity to provide examples for industry members and nonprofit entities, something that they have with them in the event that they're having an event and can't speak with someone. Okay, option 2 covers nonprofit entities selling alcoholic beverages at temporary events. This is in the event that the nonprofit entity retains a NETI, which is the nonprofit entity temporary event permit, the NT. And this also, again, provides examples in terms of the nonprofit entity being able to receive cash donations, and it must be with no strings attached. So that has not changed. That has always been a permissible practice. However, we just elaborated in terms of what no strings attached means in the event that the industry or the nonprofit entity decided that they, their example would help them understand that example or that restriction. And then lastly, we have option 3 in terms of the nonprofit partnering with a third-party retailer. Example in terms of additional or added guidance or clarification with this specific option is a nonprofit can partner with a third-party retailer, and the retailer pulls the permit or hosts the temporary event, but the nonprofit entity also has the option of partnering with a separate or a second nonprofit entity, and that nonprofit entity can pull the NETI for the event. So the first nonprofit can have the sponsorship agreement. And I know that's a lot that I just said, and that's why we have it here now in this advisory, because I know that can be a lot of information for an unlicensed entity or nonprofit to take in at that time when they're verbally speaking with someone in the field. All right, and then lastly, another example for option 3, the nonprofit entity, and as an example of allowance, nonprofit entity may hire an unlicensed organizer or promoter to manage a temporary event. That has been a permissible practice. That is something that we have now added in this advisory as well. All right, I will now open the floor for questions or comments.
We've got one in there.
Okay.
For Bob's first question, we can clarify it.
You
Option 1.
read it out loud.
Yeah.
Okay, so for option 1, under the first bullet point, suggest clarifying that nonprofits can receive product cash donations from industry members. For the third bullet, I assume that they mean product advertising exclusivity, not pouring exclusivity. Is this accurate? Suggest clarifying the provision. We can definitely clarify that. Thank you for that recommendation. And option 3, what is meant by the second bullet, receive equal billing? So let me go there for option 3. Essentially what it means that if the retailer is hosting the event, the nonprofit entity must receive equal advertising in terms of banners, billings, and signage. In terms of, basically it wouldn't say Bob's Steakhouse event, it would say Amanda's charity event at Bob's Steakhouse. So it is just in terms of equal announcements or equal billing for and acknowledging that nonprofit, that this is in fact a nonprofit event. I hope that answers your question. Any other questions? I'll give it a couple more seconds. Thank you, Bob. All right, well, if there are no other comments or questions, I will pass this back over to Shayna Horton. And we will go back to Rule 41.
3394.
I'm sorry, we have one. Is she wanting to speak? I don't see it.
She got her microphone on. Amy Harrison, do you have a question?
Amy, do you?
Yes, thank you, Joe. My question went right back to the equal billing on the advertising. That's been a discussion that internally the commission's had for a long time and wanted to use those words, but internally we could never find a way to really enforce that. And I'm just curious, what enforcement measures now are you comfortable with that you included that wording? And how will that be determined? In your example, it's that their name be on the same sign. But will that apply to all social media? Does that pertain to cost spent in advertising? I'm just curious how that will be regulated in determining what is equal. Thank you. You all have done a great job, by the way. Thank you.
I will go ahead and have Attorney Cherry answer that question.
I think at the moment, what we'll end up doing is we may end up removing the word equal. The intent of it is not necessarily that every time the actual event gets promoted, that the charity has to be promoted in the exact same way. The underlying purpose of that is that the charity or the nonprofit organization is also being promoted as well as the event and not just the event. So I think maybe taking out the word equal, and then we'll go in and clarify a little bit more kind of the intent of that and clean that up and then get back with you.
Thank you, Amy. That's a good recommendation.
Thank you.
Do we have any more questions or comments or recommendations? Okay, so we will now go back to Ms. Horton, and she will clarify questions for chapter 41.
Okay, thank you, Amanda. We did get some additional questions in chapter 41. I'm going to read them aloud, but I think we're going to have to get back to you on them from Bob Hunt, Molson Coors. In 4123, I saw retail samples for non-resident sellers and distillers, but did not see anything with respect to retail samples for brewers and non-resident brewers. I will look into that and get back to you. These, I start with the rules that we have. So if we didn't have a rule for brewers and retail samples for brewers and non-resident or brewers, then that's why it's not there, because I was revising what is already there. 4137, while unlikely, it would be helpful to remove the advance notice of destruction requirement to the TABC. Also, potential opportunity to simplify the beer destruction exemptions and affidavit to mirror TTB process. That is a very good, that's a good comment. We'll look and see if we can mirror the TTB process. We've been doing that in other aspects of our regulation. So we'll definitely look into that. As far as removing the advance notice of destruction requirement, I know that there have been expanded like exemptions for emergency situations and that kind of thing. So that don't require advance notice, but we've talked about this, and I understand your point. And we'll see if there's anything we can do. 4116 for the repeal of the industrial permit. Does this mean the permit is no longer required? They no longer allow industrial sales. The permit's no longer required. It just doesn't exist. So if you're using alcohol for industrial reasons, that we're not part of that we're not regulating that anymore. That's the legislature just took that out of our ambit. Okay, so that's the last of chapter 41. Now, chapter 41 currently okay. Chapter 41 currently includes Rule 4148, which what is the name of that? Open that up real quick. Changes relating to control. There it is. And chapter 33 contains 3394 currently, which is reporting permit or license changes. We noted that there was an awful lot of overlap in those two, and that also it seemed odd to have them in separate places since they were so closely related. And so what we have proposed to do is to take to just remove 4148 and incorporate its provisions into 3394. So it's all in one place. And in the licensing chapter rather than in the auditing chapter. Essentially, we've pulled all of the generally applicable provisions up to the front as usual. We have defined effective control and managerial control similarly to how they were defined in 4148 with just some revisions for more clarity. Let's see. And other than that, we've just really just found a way to mash everything together. We've amended, let's see. We've amended versions of 4148E as subsection K, determination of effective control. So that's one that you'll want to take a close look at. And also F is an amended, I'm sorry, L is an amended version of 4148F. So you'll want to look closely at that as well. Let's see. I'm just going to open up the floor to comments and questions about this one. I think most of the changes are probably pretty self-explanatory for clarification purposes, but let me know what you think. So any comments or questions about this draft 3394? Do you think that it's wise to combine those two rules, or is there some reason that we shouldn't? And do you think we've done it properly? I'm not seeing any hands or any comments. Which is great. Amy Harrison.
Leave it to me. And you all are doing great. I really appreciate this. Couple of just general comments. now that I'm in the real world, I'm finding out that 30 days and 10 days are not very practical with reporting, because in most cases, unless it's a very small business, the information just doesn't filter to where it needs to go. And to put it on applications and information for the commission within 30 days and 10 days is sometimes very problematic. And so sometimes with those days, I find that we're setting people up for failure before they even get out of the box. So if there's anything that can be given in the way of time, I think it would be much more practical to what real businesses face these days. The other question I have goes to the reporting and changes of reporting from what was placed on the original application. And most of us out here really don't understand what in the way of data is migrating into AIMS. And so if previously you reported a great deal of ownership, and now in AIMS, depending on what the decisions are in reporting ownership, how are those two things going to balance moving forward? That's just, I'm curious about, if I reported something years and years ago in the legacy system, and now there's been a change, how will I report that moving forward in AIMS, and will that same reporting be required?
It will be required. I am not sure how it's going to work in AIMS. I will be the first to admit that that's outside of my purview of what I do, and it's very challenging. So is there anyone else in this room who knows? Okay, what I'm going to have to do is talk to ITD and find out just what that will look like and what will be migrated. If there's something migrated over that you know is out of date, it will need to be, under this rule, it will need to be updated, and I will find out just how that's going to work. But let me talk to our IT department and get back to you.
Thank you.
I think she has the same question from the licensing services. So that
Okay. Yeah, and Miriam Morlock just reminded me that an answer to that question is going to be part of the FAQs for licensing for AIMS. So we will have an answer to that published, but I will also get back to you. Anyone else?
just Andrew clarify.
Yeah, no. Okay, and yeah, sorry for omitting that earlier. I think that's our last item. So if
Oh, yeah, the ones he asked earlier. She got it.
all right, anybody else on anything we've talked about today? Last call for this particular meeting. Okay, well, I'm not seeing any raised hands or comments, so we'll go ahead and wrap it up for today. And again, as I always say, we really do want your participation, and the sooner the better. And keep in contact with us, and we'll get these in really good shape before they get published. So thank you all so much for your participation. We really do appreciate it, and you'll have a great Friday and a good weekend.